Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw. We bring you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. Starting with the update on the Habeas Corpus petition before the Tamil Nadu High Court, which challenges the arrest of Tamil Nadu Minister Senthil Balaji and allowing him to be shifted to a private hospital for medical treatment. Senthil Balaji's family today argued before the court that there was a violation of Section 41 of CRPC and Article 22 of the Constitution by the Enforcement Directorate. The submission was made by senior advocate N.R. Elango before the bench of Justice Nisha Banu and Justice Bharat Chakravarti. He also argued that the Supreme Court had made it clear that the 15-day custody period could not be extended in any circumstances. While Solicitor General Tushar Mehta, representing the ED, argued that the habeas corpus plea was not maintainable, Elango said that the court had the discretion to entertain the case. The matter has been posted to June 27th for arguments on behalf of the ED. Meanwhile, the SG also requested the court to consider the matter of exclusion of period of hospitalization from the custody period. The court agreed to consider the issue. Stay tuned for more updates on the matter. The Kerala High Court today set aside the order of the single judge that directed the Kannur University to re-examine the credentials of Priya Varghese to be appointed as Associate Professor. Priya Varghese is the wife of K.K. Ragesh, Private Secretary to Chief Minister Pinarayi Vijayan. A writ petition had been filed by Dr. Joseph, who was ranked after Varghese in the rank list, challenging her inclusion, stating that she was not qualified for the post as she did not have the prescribed 8 years of teaching experience. In November last year, a single bench of Justice Devan Ramchandran had held that Priya Varghese did not possess the requisite teaching experience to be appointed as associate professor and had directed the competent authority to reconsider her credentials and decide whether she should continue on the rank list. In an appeal by Priya Varghese, a division bench of Justice A.K. Jayasankaran Nambyar and Justice Mohammad Nayas CP set aside the order of the single bench and held that the period spent by her on pursuing her PhD degree under the Faculty Development Program could be counted as teaching experience. The court also made some critical observations against the media coverage of the case, saying that an individual's right to privacy was not only against the state but also against private parties such as the media, and that media must exercise caution while reporting court proceedings, as not everything said by a judge during a hearing reflects the judge's view on the case. To read the full judgment, you can visit our website at livelaw.in. The Karnataka High Court today took strong exception to the claim made by the state government that only 38 government schools in the state did not have proper toilet facility. The court was hearing a suo motu public interest litigation based on media reports highlighting a large number of children dropping out of school. A division bench of Chief Justice Prasanna B and Justice M.G.S. Kamal, as a test case, perused the photographs annexed in the compliance report of 2 schools where the government claimed it had provided toilet blocks. On going through them, the court said that there was nothing to show whether the toilet block was for girls or boys. It was in a very shabby condition, least to say pathetic. Even drinking water was not available in some schools. It was carried overhead by some attendant or brought from outside. The court further said that no parent would like to send his ward to a school with such a toilet facility, as it was only for namesake, that is, 4 walls and a door. The court has now directed the state government to conduct a fresh survey of the schools within 3 months. And wherever no drinking water facility is available, the state government has been directed to provide drinking water as an immediate measure. And now coming to an update on the infamous coal and cattle scam in West Bengal. A division bench of Chief Justice Sivang Nanam and Justice Ajay Kumar Gupta today set aside the order for transfer of investigation in the case to CBI. The appeal arose from an order of a single judge which transferred the investigation into murder of alleged coal mafia Raju Jha to the CBI. The CBI argued that the victim was himself one of the accused in the scam, and due to the reasons of certain high ranking officials themselves being under investigation in the scam, the investigation was transferred. Also, the murder was allegedly related to the investigations already being carried out by the agency. Upon hearing both sides, the court held that while it was within the powers of the single judge to transfer investigation to the CBI, such power must be exercised sparingly, and the order to that effect must be well reasoned. The court observed that there must be a proven live link between the investigation sought to be transferred and related investigations being carried out by the CBI. In another update, the Bombay High Court today directed the local planning authority and state prison officials to ensure separate clean drinking water for the Taloja Central Prison inmates at the earliest. The bench of Justices Revati Moite and Gauri Godse was dealing with a petition filed by Abhay Kurundkar, a former cop and an accused in the murder of another police officer, who is an inmate of Taloja Central Prison, seeking adequate water for the inmates of the jail. The bench was informed that there was severe water shortage, with inmates receiving just 1 or 1.5 buckets of unclean water a day for drinking, washing clothes and utensils, bathing, as well as toilet facilities. The court observed that the first priority was drinking water to all inmates and directed the state to take instructions regarding steps to ensure adequate water supply within 2 weeks. The Madhya Pradesh High Court has ordered the state government to ensure that no religious education is imparted to children residing in shelter homes registered under the Juvenile Justice Act. In this case, an FIR was registered against Archbishop of Roman Catholic Church, Diocese of Jabalpur, and a sister of Convent Asha Kiran Institute. The complainant in the case had carried out an inspection during which it was allegedly found that Hindu children were forced to read Bible and visit church. Allegations were also made that children were not allowed to celebrate Diwali and were forced to do Christian prayers. Justice Vishal Dhagat observed that education under Section 53 of the Act did not mean religious education. Therefore, managements of shelter homes should provide secular education to students, which will result in their growth. The Punjab and Haryana High Court has issued a notice to the Chandigarh administration on a transgender person's plea, seeking directions to allow the petitioner to apply for the post of constable under the transgender category. The petition has been filed by Saurav alias Kittu Tank. He was India's first transgender person to climb the 6,000-meter high Virgin Peak in the Spiti Valley of Himachal Pradesh. The police said that there was no option to apply under the transgender category. While issuing the notice, Justice Vikram Agrawal ordered that in case the petitioner submits an online application form mentioning the category as a transgender person, the same shall be accepted. The Delhi High Court has issued a notice to Jamia Millia Islamia and the Union government in a petition challenging the recruitment notification for the appointment of non-teaching staff in the university for not extending reservation to the SC and ST categories. Ram Nivas Singh, along with others belonging to the SC and ST categories, has sought quashing of the resolution passed in 2014 by the Executive Council of the university, which said since Jamia was now a minority institution, it was not bound to follow the reservation policy of Government of India as per the exemption under Article 30 of the Constitution. Observing that the matter required consideration, Justice Vikas Mahajan issued notice to the respondents and directed them to file a counter affidavit within 3 weeks. And lastly, the Bombay High Court has pulled up the central and state governments for delay in procurement of working mobile phones compatible with the Poshan Tracker app for Anganwadi workers in the state. Under central government's Poshan Abhiyan mission, Anganwadi center reports are to be digitalized, and the Anganwadi workers have to enter daily logs of their work on the Poshan Tracker application. According to the writ petition, the mobile phones given to the workers for this purpose in 2018 have become obsolete, but the Anganwadi workers are still threatened with disciplinary action for not submitting digital reports. According to the communication received from state government earlier this month, no incentive was paid to Anganwadi workers in 2022 and 23 as they did not enter data due to non-functional mobile phones. The court said that this situation was absurd and entirely unacceptable. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us.